You need to introduce it again.
Welcome back to House General and Finance. We took a 1 minute break while our fire department personnel came in here to determine whether there is apparently an odd smell in the building. And the question is there a gas leak somewhere and was it in here? And it's not, and we were authorized to continue. So we're continuing and we're taking testimony on S-125 and our legislative counsel, Sophie Statney, was going through existing statute, which is so badly written that it's almost impossible to believe. Okay.
All right, Sophie Zagatny for the Office of Legislative Counsel. Just to resume, we're at the bottom of page 4, and subsection G4A is the new language that came in last session, Act 117, and this is either called card check or majority sign up. So this is the alternate process, and this is only for certifying a new unit. It's not for decertification. But to certify a new unit, you can now, instead of doing an election, if you have a showing of interest of 50% plus 1 of employees in a bargaining unit that's determined to be appropriate by the board can go ahead and certify the labor organization or whatever as the exclusive representative of the bargaining unit. So that's the alternative way.
So the fact that every other section here, when it says certification, it really means certification plus decertification. That is not true somehow with this paragraph.
So
If it were, then we wouldn't even need to think about this legislation.
right. So if you go to the very top of page 5, you'll see it says when no other person or labor organization is currently certified or recognized as the exclusive representative of the employees in the bargaining unit. So that's essentially saying you can't use this process to decertify if you already have a bargaining unit in place that's represented.
Wait a minute, where are you?
The very top of page 5.
Right here.
Certification representing.
Top of page 4. Oh, he's starting in the beginning of the sentence.
Collective bargaining representative. The only available pursuant to G4 when no other person is currently certified as bargaining. Okay.
All right, and then I'm just going to H just provides that once you've had an election and you've elected a representative, they are the representative for a minimum of 1 year. So you can't decertify within the first year. And I'm not going to go through I and J and K because those aren't really relevant to this. That's just talking about the procedures for grievances.
So there is no, presumably, you want to form a bargaining unit. Once you do that, there's a 1-year blackout period, essentially, where you can't, no one could come in and try to certify another union, or decertify that union.
Well, it's not the union, it's the unit itself.
It's the unit.
So, I mean, they could come in if they're organizing another group of employees for that employer, they could be doing that. They just can't come in and seek to challenge the union that's representing the unit that was just certified.
Okay, so the decertification, what happens when there's no union?
You wouldn't be decertifying if there's no union.
No, say that when you want to certify, I'm just a little unclear on how things work with the unit versus union. What happens when you want to unionize, a union wants to unionize a plant? And do they use this mechanism? They're not certifying units, they're getting themselves certified to represent the employees generally? Or do they propose a whole bunch of units? How does it work?
Well, so again, this is the State Employees Labor Relations Act. So,
Yeah.
I mean, if it's a plant, probably you'd be under the National Labor Relations
Okay,
Act.
well, right, okay.
But right, for state employees, so again, I can just use an analogy with the Vermont State College system, right? That the faculty, right? That maybe that a union comes forward and says, we'd like to, we want to represent the full-time faculty of the Vermont State Colleges or the University of Vermont. So that's a unit, right? They've got a community of interest. It wouldn't be an over-fragmentation to do that. And then you can have a separate unit, janitorial, custodial, administrative staff would be in a separate unit.
So petitions to certify, to create a union, to certify are always referring to a community which is going to become a unit. I mean, it's just part of the certification.
Right,
And to decertify, same thing. They're talking about a unit. They want to decertify the union for that unit.
Or they might want to break up the unit. I mean, there may be, you know, we're all part of this one unit, but we think our interests are different enough that we'd like to be our own separate unit. You can also have, again, I don't want to make this more complicated than it is. You can have units to clarify, I mean, petitions to clarify the unit.
Sure.
You know, and again, jobs change over time, right? So what makes sense in the 1970s, having this group in a unit may not make as much sense, you know, 50, 60 years later, it may, but yeah.
But there is a 1 year, obviously, that with certification, there's no contract to
Right.
begin with.
Right,
So there's no contract period or anything like that. There's just this statutory provision that says once you certify, there's a 1 year blackout period where you can't attempt to change that with a decertification.
right. Once the Labor Relations Board has said this unit is going to be represented by this organization, then that's, yeah.
You have a question? Didn't you have a question?
I do, but not necessarily on what you were asking.
Well, I got my question.
Okay. I'm going back to your other handout
Okay,
from earlier this morning. And I appreciate you sitting down or standing with me at lunch and walking me through the timeline. So I just want to confirm that this is just for CELRA.
right. This is for the State Employee Labor Relations Act. We've got those 7 acts. This is for one of the acts.
So then the State Labor Relations Act, the Municipal Employees Relations Act, the JELRA, and all of them would be 30%. Correct? This is not specified.
They all have certification, they all have decertification provisions, and I think I listed them out on the, I just pulled out and then I let it again. Literally just had it. I think on the page, there it is. Is it right?
in the back.
Yeah, I think under Vermont, I listed out, so it doesn't, I didn't see a specified threshold for decertification under, and it's a typo, but the Judicial Employee Relations Act and the Teachers Act, but the State Labor Relations Act and the Municipal Employees Relations Act are also 30%.
What happens if it's not specified?
I don't know. I'd have to go back and look and see. I mean, I did this some time ago, so I'm just not remembering off the top of my head.
Well, I mean, okay, but going back, I want to go back to this whole blackout period. For certification, there's a period of 1 year, right? After the approval.
Right. They shall be the exclusive representative of all the employees in the bargaining unit for a minimum of 1 year.
Okay, what is with decertification?
Only happened during the open
Well,
period.
where is that and what is that? Well, first of all, is the blackout period the same for decertification?
Well, if you
1 year
de-
period?
If you've decertified, then you wouldn't be coming back. You've decertified it. I mean,
Well,
unless they're looking
No,
to,
presumably, if you, well, let me ask you, decertification. Let's say someone wants to come in and say, we don't want Union A representing this bargaining unit, we want Union B representing. Is that all in the petition?
so if someone's, when you're having a decertification, the choices can be having no bargaining
Yeah.
unit or having a different,
Right,
keeping the one you have, having a different one, or having no bargaining.
so if you can't say. We want Union B instead of Union A.
Yeah, that would be one of the choices you would
Okay,
have.
so if that happens. And Union B is selected, instead of the current Union A,
I see what you're saying.
then that's it for a year. Union B is representing them for a year, right?
Right,
And there's no chance to reopen that for 1 year, right?
that's what the statute seems to
Okay.
say.
Well, is that the open period that people refer to?
No, the open period is when you're getting, so under the State Employee Labor Relations Act, it doesn't apply to everybody covered by that, because I know it doesn't apply to the higher education institutions, but under SELRA for state employees, it's a 2-year contract.
Right?
So,
So say 2-year contract,
right,
it's not just up to the parties.
right, it's a 2-year, because it's tied to the, you have to approve the budget, right? The appropriations to cover any agreement on wages, et cetera, needs to be approved by the General Assembly.
Yeah, so what is the meaning of that in terms of decertification? You can't decertify while there's an active contract, is that the idea?
I mean, typically when you're getting towards the end of a contract would be the time at which you would decide, that's when you're making the decision. And you had asked about the timing. And again, I would defer to the BSEA on this because they're going to know this much more than I do. But I think the testimony, I did see it and I'm not remembering where I saw it. It's tied to, here we go. If a collective bargaining agreement is in effect, which covers any or all of the employees to be covered by the petition, a petition shall normally be considered timely only if filed during the period 150 to 120 days prior to the date the General Assembly convenes in regular session for the year during which the collective bargaining agreement expires, or if filed after the expiration date of the agreement, if a successor agreement has not become effective. And then the petitioner would need to justify why the normal time period should be waived. And that's in the rules. So there are rules that are also associated with the State Employee Labor Relations Act.
So if I understand it, the theory behind this is that if you've got an active contract, you can't switch horses during the period of an active contract. You can prepare to. So 150 days before the end of the contract, right?
I can send it to you. No, it's signed. It's only filed during the period 150 to 120 days prior to the date the General Assembly convenes in regular session for the year during which the collective bargaining agreement expires, or if filed after the expiration date of the agreement, if a successor agreement has not become effective. But also, if you've got good cause, you could also, ask the Labor Relations Board to, to waive the time period.
So do these contracts, these 2-year contracts, do they expire?
Yes, typically.
I would assume, do they expire typically at the end of the fiscal year?
Again, you would need to ask the VSEA on that. I mean, I would say for the higher education ones, they typically expire June 30th and start on July 1st. They're aligned with the fiscal year.
So
But that's
it's
not,
kind of 4 months plus. So sometime, typically we convene in the first week of January. So sometime starting 4 months before that is when the open period begins, right?
again, I would defer to.
Okay, well then,
VSEA on this.
all right. But there's 2 different open periods. They're just different because it's for a different purpose. One is a blackout period for a year after certification. Okay, I'll have to ask because I do not understand the combination of these 2 items, the 1-year thing and all of this, but okay.
I might be able to help in my understanding. Is the blackout is saying, let's give the unit or whoever's representing you a year to show their competency, and that you can't just be like, oh, they made one mistake.
Right, yeah, okay, got it.
But the open period is, say you've had somebody representing you for 2 contracts.
Yeah,
And now all of a sudden there's something kind of going on, you want to see a change. That's when you would go to the open period.
right, but what happens if the open period is during the year? It wouldn't be, because the contract is 2 years.
Correct.
Right. Okay. Okay, thank you.
I was hoping to clear it up. I don't know why we did it. I feel like it's still confused.
We will be taking testimony from the further on this. We just, thank you, Sophie.
Thank you, Sophie.
So, Terry, are you in the room? And then Joe, first is Terry, then Joe McNeil, then Chris Orr, and then we'll see. So,
Great, thank you. Good afternoon, everybody. Terry Corson, State Court Administrator. Thank you very much for the opportunity that I was here Wednesday, as was Attorney Joe McNeil, regarding a proposal in S-125 that was limited to removing supervisory employees from the judiciary's list of exempt employees. And the judiciary's list of exempt employees, to just kind of refresh or remind, includes judicial officers, division heads, managers, supervisors, confidential employees. And the proposal is to remove supervisory from the list of exempt employees. And we had geared our testimony to the fact that we have 4 supervisory employees in the judiciary. We spelled out the reasons first to make it clear we had no involvement in the extensive discussions that Mr. Howard indicated took place in the Senate. We weren't involved in any of those, had no opportunity to weigh in, and wanted to make clear that it didn't come over here unopposed. It was that there was no opportunity to explain the reasons why we were opposed to it. But I've since learned that apparently the intent is not to limit the categories of persons to remove from the list of exempt employees to supervisors, but also to managers. And that information came out in Mr. Howard's testimony when he made specific reference to court operations managers. And he said to supervisors, potentially supervisors in the call center. We have no supervisors in the call center. We only have a court operations manager. So for him to make reference to this applying to court operations managers, which are clearly managerial, broadens the scope of this way beyond what we saw and what we were alarmed at, even with the supervisory category. And we explained the reasons why we didn't feel it was all appropriate to remove supervisory employees from the list of exempt employees. But if the intent is to, in fact, remove managers from the list of exempt employees, that is a whole different level of reason why we would oppose it. The justification for removing supervisors was a reference to the executive branch, and the executive branch having supervisory employees part of the bargaining unit. And they were saying, well, if it's in the executive branch, then why not in the judiciary branch? And we explained the reasons why. But even the executive branch doesn't include managers in the bargaining unit. They're exempt. And that's how we would want judiciary management to also remain exempt. But this proposes, or at least based on the testimony and information that I learned after the fact, that Mr. Howard indicated it wasn't 4 employees, it was more like 20 employees, which is the number of court operations managers that we have. I just felt it very important that it be clarified. If the intent of this is to remove management from the list of exempt employees, that needs to be made crystal clear. And we need to have the opportunity to explain why that would be an even more egregious breach of labor relations law time immemorial. You have management and non-management. And if this proposes to include management in the bargaining units, it's going to put us at a distinct disadvantage in terms of having candor and the ability to interact with our managers and all of the roles that they play that are very, they're privy to much confidential, sensitive information, staffing levels, budget, salary, discipline, all of those traditional management roles and responsibilities that we need to have the ability to discuss with them in all candor. It'd be as if we're saying the union has their meetings to which we're not invited and we shouldn't be invited, and they can speak in all candor in those meetings. If our management is part of the bargaining unit and they come to our meetings, it's as if our meetings are open then, and we lack the ability then to be able to discuss things openly, to be able to manage the contract, discuss strategies, all of the confidential information that we'd run the risk of it being shared inappropriately. So I just wanted to explain that we oppose the removing supervisory employees for the reasons explained Wednesday. But if the intent, and it appears that the intent is to include
Just for want to refine or disagree with what I'm saying. The evidence that we heard this morning from Mr. Howard was that there was no intent of changing the status of managers, and that the question simply of who is, Mr. Howard testified that the question of who is a supervisor and who is a manager and who might be a employee that has confidential information is a typical question decided by the NLRB, by the VLRB. That's what they do, and that they're arguing that that determination should be up to them. And that they're saying that the group of people might be larger than your group, but that not we, but they should be the people who decide that. That was their testimony.
And I apologize, I was scheduled in Springfield this morning at a.
Yeah, no, that's okay.
So I didn't.
Terry, that's, I just didn't want to let you
Well, I
let
appreciate
it
that.
go. I don't think there's any of us understood that we were scratching out management as well as supervisor in the intent of this statute.
Well, but if the plan is to have the VLRB decide whether or not our court operations managers are supervisors and not managers, then in the number that was posited as 23, which is the number of our court operations managers, it sounds like it is their intent.
Well, it may be their intent, but it's not, their intent was not to suggest that we eliminate, that we amend the list to take out management. I'm just saying that they're testifying that the question of who is the manager and who is a supervisor is one that is typically often in these situations, in every certification situation, comes before the VLRB, and they would have to decide that. I have no idea what their decision would be. Yes.
May I ask a question of Sophie? And I'm so sorry. This portion, or this section of the bill, is it just for Jelra? Or is it for all?
So Sophie Zagatni for the Office of Legislative Counsel, it would, that provision is just for the Judiciary Employees Labor Relations Act. It's not for any other act, it's that section is specifically under JELRA.
Okay. But in other acts,
So in
is
Cel,
supervisory included or excluded?
so under CELRA, which is the most analogous,
Yeah.
which is the State Employees Labor Relations Act, supervisors are able to organize.
Okay, thank you.
Well, I guess I would say that if there is the possibility of court operations managers being encompassed in the supervisory definition, and this allows that, we would absolutely oppose that for all the reasons. Our hands would be so tied if we were not able to discuss things freely with our court operations managers or any of the managers in the judiciary.
Well, I think it'd be useful. You want to tell us what a court operations manager does?
A court operations manager is responsible for the day-to-day operations in each of the individual courthouses. In the smaller courthouses, you might have a court operations manager who oversees the civil docket and the criminal docket, for example. In the larger courthouses, you'd have typically a court operations manager for each division. For example, in Chittenden, there's a criminal court operations manager, there's a civil court operations manager, there's a probate court operations manager. They're responsible for managing the judicial assistants that are in that division, people working the counter, working the phones in the courtroom, day-to-day operations for each of the courthouses. Court operations manager is the title. And they work very, very closely with, we have regional superior court clerks who are responsible for a region, Windsor, Orange, Wyndham, Bennington, Rutland, Addison. So the Superior Court clerks work very closely with the court operations managers, with whom I work very closely to oversee operations and implement basically ultimately the policies and goals that the Vermont Supreme Court establishes. We implement, the Vermont Supreme Court by the Constitution is responsible for administration of the courts. So they set the policies, they set the goals. My job is to implement the policies that the Vermont Supreme Court sets. And ultimately, it's the court operations managers and the judicial assistants who do the day-to-day work in the courts. They're recording the cases, they're intaking the e-filed cases, they're scheduling. So we're a team. And I think as Attorney McNeil described, a lean and mean team. We have, a small budget, we have a small workforce, but everybody works very hard. And I feel we've made tremendous progress and work. I worked in the courts also some years ago as Rutland. I worked as an attorney for 25 years in Rutland. My husband, we worked together. We met in law school. He was appointed to the bench in 2008, and I couldn't appear in front of him. We didn't want him to have to work, hours away. So there was an opening in the Rutland County Clerk's office. So I worked in the courts. And to me, it gives me a great advantage to be able to say with all sincerity to court staff today, I know how hard you work. I know how hard the job is. And I see my job is to support them. The whole court administrator's office, whether it's the tech division, whether it's the finance and administration, the budget, whether it's planning and court services, whether it's trial court operations, our work is to support those people doing the day-to-day. Because that's where, in my mind, justice happens, in the courtroom, in the courthouses. So our whole purpose is to support them, to come here to advocate for money for them, and to provide whatever support we
You
can.
have some questions here, Sally. Do you have a question, Gail?
Can you describe what the role of the supervisor is?
The four that we have.
Yeah,
And what we did, and I learned this because I've been in my job for just 2 years, and they were named supervisors several years ago. They supervise at least one employee, and one supervises three. One's in accounting and supervises 3 employees in her department. 2 of them are court security. They supervise either statewide court security officers or security officers in the Costello courthouse. And the other one is in tech and supervises the help desk personnel. But my understanding of how it came about that they became supervisors is as work evolves, we try to figure out how to best make things operate. It was for them to oversee 2 or 3 employees and learn that, that then would enable you to have a supervisor title, which would give them increased pay. And it was done to, help them, to advance them. And that's how it came about that those 4 then had supervisor in their title, because they technically supervise 2 or 3, employees. So they are a resource to the employees. They might, with respect to the court security officers, might do the scheduling. The way it works, especially in the statewide realm, is if you have somebody who calls in sick in Wyndham, dispatch somebody to go to Wyndham so that you don't have to cancel hearings, so that things can continue, to make sure there's adequate security,
Mhm.
in each of the courthouses. Scheduling might be the one administrative task that they would have, or be a resource if the person needs help with whatever, their work is, that they have somebody that they can go to. And then those supervisors are under a manager in each, for each of their areas. We have a director of security for the court security officers. There's a manager for all of the finance offices, not just accounting. And for the tech, they have different divisions: data, help desk. I can't even begin to explain, but configuration, I'm just going to repeat in terms
Mhm.
without knowing what they really
Thank you.
mean.
Other questions of Terry? Sally, was alleged to me that the fact that she was waving her finger around did not mean that the other question.
Oh.
Is there anyone else has a question for Terry? Terry, thank you so much for coming back.
Well, thank you. And again, we would urge you to not pass Section 5 of S-125 for these reasons, especially if it could mean that our managers would be subject to this, which again, not even the executive branch has that. they're considered exempt employees and we would want the same. May I ask if Attorney McNeil had anything he wanted to?
He's next on our list.
Oh, okay, great.
So in fact, you can stay there and maybe if there are questions. Joe, did you have anything you wanted to add to?
Yes,
Terry's
please.
testimony?
Yes, please, if I may. First of all, I do want to point out that although it is true that the bill as written would continue the exemption of managerial employees in GELRA like managerial employees in SELRA, the State Employees Labor Relations Act, does. It is important to understand that at the time GELRA was written, there was a careful distinction made between supervisory employees and managerial employees for that construct, with the idea that both would be excluded from bargaining units. Now, if managerial employees are to continue to be excluded, but supervisory employees are not, I would say to the committee that it is important for you to look at the subtle distinctions between the definition of manager in SELRA, which is found at subsection 18 of 3 VSA 902, and the definition of managerial employee in GELRA, which is found at 3 VSA 1011 sub 13. Much of what is there is similar, but there are distinctions to be made, and I will predict that if this bill is passed and supervisory exemption is repealed from the bill, then on petition for representation of individuals, classifications of employment that the VSEA asserts are supervisors but not managers, and the judiciary believes are definitively managers, there will be discussion about the differences between the managerial definition in GELRA and the managerial definition in SELRA. And it would be fair to say that neither the House nor the Senate, neither the Senate in its consideration or the House in its current consideration, have taken the time to fully understand the subtle differences that later can become critical. So in effect, the Vermont General Assembly will be completely and somewhat blindly punting to the Vermont Labor Relations Board this question, which will lead to considerable time, considerable expense, and considerable disruption for the judiciary to have to demonstrate why it is that the category identified by Mr. Howard as a solicited category being solicited, that is the court operations managers, should be regarded as supervisors and not managers. I would also point out, in answer to the question that Terry was answering just recently, it's very clear that the court operations managers exercise supervisory authority. No question about that. They help with hiring, they discipline, they evaluate, they assign. But beyond that, they're involved with the management of the court system in policy determinations, in the direction of the judiciary, in terms of service to the public, service to the judges, service to justice, ultimately. Now, if I may additionally, try to help the committee with questions that were being asked before Terry spoke about the, if you will, the blackout period and the period during a contract. If a labor organization is certified, and as you know, certification can come right now either by election or by checkoff of authorization cards. But if a certification of a bargaining unit occurs, there is a 1-year period during which no other union can solicit to be the representative, and no decertification petition can occur unless and until a collective bargaining agreement is reached. Once a collective bargaining agreement is reached with that bargaining unit, then there is what is called a contract bar. And during the contract bar, which lasts almost for the complete duration of the contract, there can also be no decertification petition, nor can there be the acceptance of a filing by a competing labor organization. So there's two concepts, and it seemed like your question, Mr. Chairman, was about how the two interacted. That's how they interact. You also had a question at the last time about the duration of contracts under SELRA. By statute, those contracts can only be for 2 years of operation. Unlike, let's say, municipal contracts or school teachers' contracts, which very often are longer than 2 years. And the reason for it was as indicated just recently. The reason for that 2-year bar was because it lined up with a particular session of the legislature, and the statute for collective bargaining requires legislative approval of the funding necessary to support a collective bargaining agreement. The process for bargaining is not over until the legislature concurs on the funding part. But going back to the question at hand for the judiciary.
Joe, could I ask you a question before we go to that?
You certainly
I
may.
just want to clarify about the operation of the 1 year, period after certification and the other bar. So if a group is certified,
Yeah,
the fact that it's certified, a bargaining unit is certified, doesn't mean there's a contract. Then they have to negotiate a contract.
that's correct.
So it might take,
So-
let's say it takes 6 months to negotiate a contract. So they
Yeah.
negotiate a contract. So on January 1, I'm just doing this to get it clear. On January 1, they're certified. Well, of course, it'll be January 2. January 2, they're certified. May 30th, they have a contract. The 1 year blackout period, there is a period of 1 year to the end of till December 31st. No one can challenge the certification.
It's slightly different than that, Mr. Chairman. So let's take two examples. Your situation is that the certification occurs on January 2nd.
Yeah.
Let's assume that the parties have begun negotiations, and they've continued negotiations unsuccessfully all the way through the year.
Right.
And by January 2nd of the ensuing year, the employees, just as an example, are not happy with the lack of progress on the creation of a contract. So at that point, within the 1 year, after immediately after the 1 year, there being no contract, there could be a petition filed by a competing union, or there could be a petition filed to decertify the existing union, and that would be okay. But again, on your example, let's assume the certification occurred on January 2nd, and by May 31, there is a 2-year contract. Well, as soon as that contract is ratified and signed, then
Right.
you don't worry about the blackout period anymore.
Right.
There is a contract bar to decertification until the very end, within that period of time, the 150 to 130, whatever that statutory factor is. That's how it typically works.
The bar is until, it's actually not till the end of the contract.
Right towards
Technically,
the
it's
end. That's-
before that, it's near then when under this, when it's, so there's a bar, as long as, the idea being if there's an active contract, until near the end of it, there's a bar.
That's correct. That's
for
correct, Mr. Chairman.
decertification, because the theory is if you've got a contract, then we don't want to mess with that contract. We want to change
That's-
horses in the middle of a contract.
That's right.
Okay,
That's the distinction.
thank you. I interrupted you. You were gonna say, you said, as to the matter at hand, comma.
Oh, as to the matter at hand, I was just going back to the notion that when the judiciary asked me to testify, it was under the impression that this was all about four job titles that the judiciary itself had labeled as supervisory. It became apparent from Mr. Howard's testimony, and he was very forthright, that what this is really all about is a desire on the part of VSEA to attempt to organize job titles that the Judiciary Department definitively believes to be not only supervisory, definitely supervisory, but also managerial in nature. And what we're arguing is that that would not only seriously impede the operations of the judiciary as we know it today, but it would be blind to perhaps the distinctions that exist in SELRA and GELRA relating to what is and what is not a managerial employee, leaving that entirely to the labor board, which in and of itself will create significant time and expense with regard to the determination as to whether the title represents a supervisory function, a managerial function, either or both. And that is why, on behalf of the judiciary, I reinforce Court Administrator Corsone's testimony that this would be a major change and create a significant difficulty with regard to conflict of interest. And one last point, if I may. I may have given the impression when I testified last time and referred to the amendments to the Taft-Hartley Act that came from 1947 that the distinction between supervisory, the exclusion of supervisory employees under the National Labor Relations Act was ancient history. That is certainly not the case. That's true to today. And I would cite to the committee NLRB decision in 2024 called the Friends of Children versus Portland, which is at 19 UC case number 323383 of the National Labor Relations Board, which contains very instructive analysis as to why supervisors and managerial employees are exempt from the National Labor Relations Act coverage because of the potential for conflict of interest. Other than that, Mr. Chairman, I think I'm finished.
Questions by the committee? Any questions?
I would like to say something.
Sure, shoot.
Hi. I did not get a chance to review every moment in the Senate. But can you talk about, there's been some discussion that folks did not testify in the Senate. Did you testify before the Senate before they added this to the bill?
If you're asking me,
Yes.
the answer is no, I did
Why is
not.
that?
And the court administrator Corsones testified on Wednesday that the Judiciary Department was unaware of the bill and was not invited to testify before the Senate and did not do so.
Well, it seemed, I'm sorry, go ahead.
We were aware, we learned
Yeah,
of
that
it.
seems pretty ridiculous that you wouldn't be aware of this, since you seem to have pretty much a lot of involvement, sir, in what's going on, that you guys weren't aware of this.
When we learned of it, I asked for the opportunity to testify. The timing was such, it was just before crossover.
Uh-huh.
And Chair Clarkson apologized. She said, we have witnesses lined up primarily having to do with the Assistant Attorney General portion of the bill. And they simply did not have time, given the crossover time limitations, and said, please go to, when it gets to the House, seek an opportunity to testify. Oh, sorry.
No, I was just saying, but they still felt the need to put it in, and I've had a bill on the wall since January for the same thing in the House side, so I'm not sure why there was a delay, and I don't know if I would blame the chair for not having that happen.
I guess we first became aware of testimony being scheduled, understanding that bills on the wall don't necessarily have testimony time. When we saw testimony, that's when we asked for permission. That's when she made her recommendation. And I did indicate to her, there are just 4 supervisory employees in the judiciary, of which she was unaware. And she said, you definitely would want the House to be made aware of that.
And
Well,
I just want to
perhaps
interrupt really
she would
quickly.
want-
I was just gonna say that I believe Terry had come to us before we had even gotten the bill, right around crossover, saying that there were provisions within the bill that there was concerns about and that she had asked to testify immediately.
No, I
I mean-
understand. I'm just confused by the timeline because, you know, the Senate put this in the bill. So for us to strip it out, I mean, maybe we'd want to hear from Chair Clarkson or someone on the committee about their thinking. But again, I introduced this bill in January on our House side and did not push to discuss it because I knew that, as far as I knew for months, that this was going to be in the Senate bill. So, you know, as we're deliberating this bill, I'm just, you know, the Senate did add it. And so I would like to find out more about why they felt and voted on it. I don't remember or what the vote was in committee, but so I'm just confused a little bit about where that's at and if why you didn't write something to them or I don't know. So just their response, Terry, was that we'd fix it and remove it in the House. Is that what your impression is, that Chair Clarkson made the assertion that we would just remove it after hearing from you guys?
She's saying that Chair Clarkson said, we don't have time for you to testify here, testify in the House. And the
But
question
still
is,
left it in the bill.
they struck supervisors from the exemption.
No, that's what she means.
That
Left it.
Oh, yeah, they left that in the bill.
Yeah,
Yes.
that's what right.
They passed the bill on the basis of the testimony before them. That's
Right.
all.
No, that's
And
what
I
I'm
think-
saying.
yeah.
So I'm just a bit confused. So maybe I'd like to hear from that committee about why they felt strong enough to leave it in and if they thought that we were just gonna, after hearing more testimony, strip it out.
I'm happy to ask, Chair Clarkson.
Thank you.
But I
Mr.
don't
Chair,
think, I mean, you
Mr.
are here, I think Terry and Joe, you're here now, you've testified, your testimony is legitimate, we're not discounting it, and in fact, I do have a request. I will take time to read CELRA section 18 and to read JELRA section 10, 11, 13.
Thank
And
you.
I will take the time to do that. And I probably, unless the committee tells me that I shouldn't, which they may, will ask Ledge Council to educate my reading. And if I do that, you may want to educate my reading as well by submitting something in writing. And I wouldn't want to prevent you from doing that, Mr. McNeil.
Thank you very much. And I want to make very, very clear that I personally, and I don't believe Ms. Corsones, we're blaming the chair of the committee for anything. If anything, we are grateful to the committee for the opportunity to testify and to have our positions considered by the committee. We attempted to do that in the House, and it was a timing issue that prevented it. And we thank you for the opportunity here.
Thank you.
Very much.
Thank you very much, Terry. And we're going to move to our next witness.
Can I-
Oh, Joe, you have a
It wasn't for you, actually. It was for Representative Krasnow, actually.
Hello.
Hello. You had said you had you have a bill on the wall striking supervisory out as well.
No. Or I have the bill on the wall, on our wall since January that is
You
the
didn't move
same.
it because she thought 125 would
I-
take care of it.
That's right.
Perfect. In your introduction, in your process of bringing that bill forward, did you have a number of people you thought it affected in the judiciary?
I mean, I believe that it's up to the Labor Relations Board to make those decisions.
Okay, I just didn't know if you had a number or.
And is my understanding that the Senate had weeks of testimony on this, which is, and I had been following, so I don't know, I'm just trying to kind of understand. It seems like a big difference to then just come here and, so I'd like to maybe dive deeper into the work that they did as well and why they felt it necessary even, and that's why I'd like to hear more about what their determination is. I know that I can't speak for other bodies when things cross over, that there's intention that maybe things would be different, but it seems like something large to keep in a bill that you just, without hearing from them. So, but yes, my intention with the bill when I put it in is that is again up to the Labor Relations Board. I would have liked to take testimony on it on our side as well, but it was my understanding that there was weeks of testimony in the Senate and that they kept it in the bill for a reason. So that's why I did not bring it up in our committee and was hoping to see where it landed. And I saw that it came over.
Perfect, thank you. And the next one is, what was the employees that you're suggesting that they're wanting to include?
The 4 supervisory.
No, the other
Oh,
managerial.
port Operations managers.
Port operations managers, okay. And can you think of any one who doesn't fit in this bucket right now that's currently not a member that would fit in? Like, would you say like, we actually have, 40, 50 members that could possibly unionize, but they're just not.
All of our non-management employees are part of the union. There's 244. And then the balance of our employees there's 90 judicial officers, for example,
Yeah.
60 managers, 30 confidential employees, attorneys, Supreme Court, et cetera. Those are the kind of the 5 categories. So the bulk of them are in the collective bargaining unit, the non-management employees. But I can't think of it.
Yes.
This kind of spells out the list of categories otherwise.
Yeah, I was just curious because when I asked earlier about, if the number is 20-something-ish around there, are those people currently unionized or not?
No.
Oh, no, that would be
They're
the
not.
operations manager.
And if, and you're saying that anyone who could unionize is at this point,
Under this law
Yes,
as it is.
Right,
Yeah.
right,
Okay.
unless and until
well, I mean,
supervisory is stricken.
unless I hear otherwise, it clearly sounds like, and I don't want to use the word poach, it sounds like there's intent behind there, but for lack of a better term, it seems like it's gonna poach from some one of these to find those other
Did
15
you
to
say,
20.
Terry, there were 90 supervisorial?
9 judicial officers.
Judicial officers,
Yeah.
they're exempt,
Right,
and there's 16 officers,
right.
and there's 30 confidential.
Yes, I'm
I
speaking,
mean, about.
yeah, yeah.
Okay. And then, so there's 240 unionized?
244.
Okay.
But it's my understanding that there are non-management employees that aren't management employees are not all in the union, and the supervisors, they're not,
They're not,
Right.
yeah,
Right.
yeah.
right? And so again, I think that would be up to the board to decide what management means, because I think there's discrepancy of what management actually means.
So
Here.
it seems like this whole underlying thing is we think you're misclassifying people.
And I'm sorry, I'm not kind of versed in Vermont Labor Relations Board inquiries into classification.
I'm just.
I just know from an operations perspective,
Yeah.
it would be extremely problematic for us not to be able to engage with our court operations managers in terms of the conflict of interest.
Yeah.
I think in my mind, ethical conflicts that would arise if this were to go forward. And in all honesty, I mean, like everybody, the courts have been through a lot between the pandemic, between electronic filing, remote hearings, everything. And I feel like we're in such a much better position. And Attorney McNeil will know far better than me, but the idea of going through
Yeah.
something like this at a time when we're just making good progress on the backlog.
So I think that's where I would just leave it, is like, after hearing everyone saying, it basically just sounds like, would it be the VSEA believes you're misclassifying people?
Well, it's not, it hasn't come up.
Like, I don't
It
know.
hasn't, the only thing, Joe, is it hasn't come up.
I'm trying to figure out where this
Right,
nobody points, the only,
whether it's
person is
4 or 20 would have to be determined if we were to pass this bill, if we were to pass this bill. If we don't pass this bill, it's a moot, nothing's gonna change. In other
If I
words, we don't,
could I just add
If we
one
do,
practical
then
example?
the VSEA, the Vermont, the Labor Relations Board would receive petitions. If the petitions included more employees than, if they didn't agree, if management didn't agree with the petition,
Yeah.
they would argue in front of the VLRB, hey, these people are managerial. They're not supervisorial, and then the VLRB would decide, are they or aren't they?
and maybe we could get, you have an assumption of who those would be that they're talking about, and maybe we could find out who they actually are that they're talking
She
about.
just went through what they do.
I know that, I'm just saying, you have an assumption of where they're getting their 20-something number.
Yes.
So,
It would be nice to know on the other side of the coin, where's your assumption of those people?
right, well, we can ask them.
If I
Oh.
could I add one practical consideration that reflects on the judiciary's view, and that would be a court operations manager has disciplinary authority, no question about it, has the authority to evaluate and has the authority to recommend or impose discipline. Part of the problem that we see with the potential addition of the category of court operations managers into a collective bargaining unit, even though it's a separate bargaining unit, would be the obligation, the interpersonal conflict between the responsibility to exercise disciplinary authority on behalf of the judiciary and disciplining one of your own union members. That creates difficulty, I'll use that term. The National Labor Relations Board would say it creates a conflict of interest to the degree that they should not be in a bargaining unit. Vermont made an exception for the executive branch when GELRA was created, and I was somewhat involved in it. The definitions between managerial and supervisory were crafted with the view that both would be out. And there are differences ultimately to be interpreted by the labor board as to whether it's the same or different, the standard for management in the executive branch versus the judiciary.
Thank you,
Um,
Joe. Joe, we have a question here. Go ahead, please.
Thank you. Yeah, no, I just need clarification on, because thank you for your testimony, and it is a lot. And I'm just trying to understand a little bit better of your understanding and your point of view. And so what I'm hearing you say is you want the ability to engage with your management, leadership, whatever the term may be, the people who make the decisions. But would that not take place? So I guess this is a different conversation because I just need more clear understanding around what those interactions look like and why they wouldn't occur. Because I was under the impression that the units were for employee issues, not for interpersonal issues within themselves. And so would if everyone works in the court staff, right, that's the court employees who are union members, do they engage with whomever else is employed by that building, right? Or no, does that not happen?
Well, for
I-
day-to-day, oh, sorry.
Whoever they are required to, like, regardless of status is what I'm confused, because that's where I'm getting confused on where the engagement barrier would come in.
Sure. It's actually an excellent question, and it goes to the heart of the matter. Take, for example, an operations policy
You know what,
that was.
Joe, I'm gonna interrupt you for a minute. I think this is an important question. I think we're about to end. I know Emily's got a question, and I think we're gonna take a break. We've been going now for an hour and a half, and I think what I'd like to do is take a 10-minute break and ask if Terry and Joe, or is it okay with you that you stay? We're gonna go offline for 10 minutes and be back here at 20.